First Appellate District of Ohio with the Honorable Marilyn Zayas as session. Please be seated.
Good morning. So we have a full house today between council. I think there's some interns back there. And then we've got some guests from the FBI Citizens Academy who's attending here today. So I'm actually an alum of the Academy, and I'm really happy that you all are here. So that way, if anyone was questioning, who are these people, now you know who these people are. So today is Monday, September 9th, and we have 3 cases that are going to be argued this morning. We have 4 cases on the docket. For the cases that are being argued, when I call your case, please identify yourself as counsel and your readiness to proceed. The first case we have is C-240146, Paquin versus City of Indian Hill.
Good morning, Your Honor. Brian Pacheco, Richard Trainer on behalf of the intervening appellant, ready to proceed. Thank you.
Good morning.
Good morning, Your Honors. Matthew Fellerhoff on behalf of the appellee, ready to proceed.
Thank you. The next case we have has submitted on the briefs. It's case number C-240197, State of Ohio versus John Dodd. The third case we have is case number C-230424, State of Ohio versus Aaron Potter.
Paula Adams with the State of Ohio. I'm ready to proceed.
Good morning, Paula.
Good morning, Angela Glazer on behalf of Aaron Potter, ready to proceed as well.
Good morning, Angela. The last case we have is case number C-240241-243, State of Ohio versus DeMarcus Cook.
Good morning, Your Honor. John Hill on behalf of the appellee, State of Ohio, ready to proceed.
Good morning.
Good morning, Your Honor. Brian Goldberg on behalf of the Marcus Cook appellant. We are ready to proceed as well.
All right, thank you so much. So, counsel, I know that we asked for supplemental briefing. I know that it was a tight time window. And so, Attorney Pacheco, whenever you're ready.
Good morning, Your Honors. Again, good morning.
Good
Brian
morning.
Pacheco and Richard Trainer on behalf of the intervening appellant, Peter Loon. Your Honor, I'd like to reserve 3 minutes
right.
for rebuttal. Thank you. Your Honor, if I may, I'm going to pull out my phone not to do anything other than just make sure I help keep my time. Is that okay?
Okay, no worries.
Thank you, Your Honor.
So you're going to keep me honest, huh?
Well, all of us, Your
All
Honor.
right.
Your Honor, I had an argument ready to go and kind of to proceed, and then we got the order on supplemental briefing. So what I'd just like to do is do something a little inordinary, maybe, or unordinary, is just ask you, the court, does the court have any question, argument, or at least briefly address the issues and then get into the merits?
Yeah, I do. So your argument made sense to me in your supplemental brief, but then their argument made sense to me too. And their argument being like, hey, there's no ordinance here. And so as I look at this question, and I didn't have time over the weekend to fully dissect Indian Hills zoning ordinance, but there was an administrative procedure that was followed here, and that's how this proceeded. Now, that doesn't mean that what the city council does is necessarily administrative versus legislative, but I think it's more complicated than just, hey, city council did something, therefore it's legislative. So maybe if you could address that and why you think it's legislative rather than administrative.
I agree, Your Honor. I appreciate those comments. It's very simple from our perspective. Did the action enact a new law, or did it administer or apply an existing one? And in this case, it enacted new law. It enacted new outdoor amplified music guidelines. There was no pre-existing law. These are not like conditional uses.
But those just apply to Peter Loon, or they apply more broadly?
That's fair. That is fair. They only apply to Peter Loon.
Okay.
But there are still new regulations that did not exist. And under the administrative process that you're talking about, Judge Bergeron, only Planning Commission has that authority. City Council did not. You go back and read 101-481 through 485, it talks about jurisdiction of the Planning Commission. Here, the Planning Commission refused to impose any restrictions. And then the Paquins appealed that. Well, actually, the Paquins did not. Other property owners did, and the Paquins joined in the city council proceeding.
See, it's interesting because your argument is premised on that there were no restrictions, and I think it's a matter of how one interprets the 1980 approval. Because the 1980 approval was very specific to a request that was requesting two specific things. And it gave a specific authorization, because it's not even clear where the statute's at hand at that time, right? And it gave specific authorization for the uses requested, right? And so, and then it referred it back to 61.155,
That's correct, Your Honor.
right? So, and 61.155 gives some restrictions. So to say that there weren't any restrictions, when by definition 61.15 gives restrictions for non-commercial entities, so it defines all of these different things, but it defines it as only as non-commercial. And in the 1980, that's where the activities is coming from. So
May I
do you understand what I'm saying?
I
You're
do, Your
saying
Honor.
no restrictions, where from the very beginning, by its nature, it seems to me that there were restrictions.
Fair enough, Your Honor. I disagree that there are restrictions for the following reasons. If the 1980 approval specifically lists and says that these activities, meaning other occasions and meetings to be held on the premises, are like the activities in 61.155, country clubs, private lodges. It was not a term of limit. It was not a term of restriction.
But
Rather, it was a term of
goes on to say, comma, all of a non-commercial nature. So the all of a non-commercial nature applies to everything that came before, which is the list and the like.
I agree, Your Honor. Those were identifying non-commercial entities that specifically in 1980, the Planning Commission said we met. It was not a term of restriction. It was a term of identification. It was not a limiter. And for 40 years, as Indian Hill indicated in the proceedings below, they, as a factual matter, determined that what we were doing with weddings was not of a commercial nature. So even if it was a limiter, Indian Hill said for 40 years, that is not a limitation or a restriction that prohibits this activity, and that's what
And where
goes.
did Indian Hill make the determination that it was not for commercial?
Well, there-
Because that's inconsistent with the testimony. The testimony was, hey, we want to subsidize our nonprofit activity with our for-profit activity, to wit, the weddings seem to be the most profitable.
So, Your Honor, I respectfully disagree with that. In 1980, they have this list, and they say you can have you can use the grounds and the premises for meetings and other occasions, sponsored by groups other than the Junior League. So you have that determination. Then they say these activities, again, it has to be read in context of the 1980 approval. These activities would be permitted under 6155, or they are alike. It just says of a non-commercial nature. And for 40 years, Indian Hill interpreted what we were doing, even charging. There's no dispute. We were charging for weddings from 1983 to 2021. What is, from our view, irreconcilable is for both the magistrate and the trial court to then say, having benefit of that record and having written it in her decision, then Judge Ruhlman basically said the same thing, is that now only the 2021 uses are unlawful.
Well, but help me out, because, like, I get that argument, but from my understanding of the record, like, going back into the 1980s, like, there might have been a few weddings here or there, but it wasn't as prevalent as it is now. And so your argument about vested right, to me, seems to prove too much, because what you're doing now, it is the same event. It is a wedding, but there's more of them. Maybe they're louder, I don't know. But, like, it can't be the notion that just because you were able to do a wedding at one point in time, like, suddenly you could turn this into, we have a wedding every single day, and we're going to have, like, live rock bands playing and whatever, right? Like, there has to be some ability for Indian Hill to regulate it, even under your theory, right?
Well, Your Honor, the concept is, sure, there is, under disorderly conduct, that you know,
Well,
everybody.
counsel, I'd like to take you back to Judge Bergeron's point. I'd like
Okay.
to take you back to the legislative administrative question, and I interpret his question to be getting at that.
Okay, yes, Your Honor.
So, to what extent do we weigh the fact that this whole proceeding was initiated by neighbors who had a complaint, And they were seeking, as I understand it, some help from their local government to resolve this complaint that they had. And there was a resolution that was passed that seeks to regulate the noise problem that was perceived to be taking place at Peterloon. That, to me, looks fundamentally different than most, if not all, administrative proceedings that begin with an application by someone for a determination of a right or responsibility, like a driver's license or a variance application or a license to practice law. So to what extent do we weigh how this proceeding began in determining the legislative versus administrative question? And then one more inquiry. An interesting feature that I noticed about this noise resolution is that it contains a remedies section to it, that it contemplates something going wrong and how that is going to be rectified or remedied, which also looks unique from an administrative law perspective. So there's some end game activities being addressed as well. So beginning and end, can you please address those
Yeah, Your
features?
Honor, I agree. I think at best this was a hybrid process, which makes it, to Judge Bergeron's question earlier and to yours as well now, Judge Kinsley, which makes it look more like a legislative act than an administrative act. Because if it were an administrative act, you'd have a specific process to be followed. Again, this was unusual for property owners to petition the Indian Hill City Planning Commission to start the process. That's not provided for under Indian Hill's ordinances. Now, Mr. Fellerhoff, I'm sure, will get up and say, well, 101-481 allows, and the Planning Commission is continuing jurisdiction, and 101-481 allows these types
And
of...
what does that mean exactly? So there is that term continuing jurisdiction, but what does that,
Right.
what does that empower the Planning Commission to do?
Right. Well, first of all, Your Honor, I'm going to answer that question. But I want to highlight your second question was to go to the unusualness of this proceeding. Again, the Indian Hill specifically code says only Planning Commission has that authority. Planning Commission, again, did not impose any restrictions after going through this hearing process. So it goes and highlights the unusualness and the legislative now nature of this as opposed to an administrative nature. So that was the first point. The second point was, in this particular context, you have folks almost looking like prosecuting a nuisance violation. And Indian Hill didn't have a way to prosecute it because for 40 years Indian Hill said there were no restrictions. City.
As I recall, you raised that argument below, but you did not raise that argument before us.
I'm sorry, Your Honor, which specific
The
argument?
notion that this could have been prosecuted as a nuisance action, that it could have been prosecuted either under the Indian Hill Code or under the ORC,
Well, Your Honor,
or
we
a
did
noise violation could have been prosecuted.
We actually did say that in our objections and our brief, but that we weren't assigning that as error. I'm simply responding to the point to where it says there's no, I'm responding to that they don't have a remedy and the unusualness of coming to Indian Hill and asking Planning Commission when Planning Commission doesn't have jurisdiction. It says continuing jurisdiction, but to your point, Your Honor, that's why it comes to the vested rights argument. Continuing jurisdiction to change the law? I mean, that's what happened, Your Honor. That's what happened. 40 years later, they changed the law on us. And that is legislative, excuse me. That's not administrative. Administrative is you have a set of rules, the party either complies or doesn't comply with them, and then city council, if it's acting in an administrative capacity, says you violated X, Y, Z. We don't have that. To your point, Your Honor, and I think you hit on it, the next case would be administrative. Let's say somebody claimed that Peterloon was violating 05-22. That next proceeding was administrative because you have pre-existing regulations that somebody's applying and somebody's enforcing, and we're either complying or we're not. That would be administrative. But the underlying proceeding here was all legislative. It enacted new regulations. And so to your point, Your Honor, I'm not sure what process this was, administrative or legislative, when it started. I submit it wasn't provided for under their code because Planning Commission started it at the request of property owners. But then, Planning Commission, who's the only authority vested under the code to enact such conditions, even if they have continuing jurisdiction, they don't have continuing jurisdiction to change the law. That's the Cook case that Judge Bach wrote earlier this year in St. Bernard. It's also the Chang case that Judge Bergeron wrote a month and a half ago, where the trial court misapplied the resolution, which is, I wanted to throw that in there because I haven't even got really to the merits yet, but I do want to say that the court misapplied the resolution. And Chang is a good example of that the court recently did, particularly Judge Bergeron. So, but anyway, back to your bigger point, Judge Kinsley. This process started in a way that was.
Attorney Pacheco, so you're out of time. I just want you to answer very briefly
Yes.
one question. One question for me.
Yes, Your
okay?
Honor.
Where in the record did Indian Hill determine that weddings were non-commercial?
Yes. Your Honor, may I have just, I'll pull it out of the transcript, thank you. I appreciate the question. It's before the magistrate. The magistrate's transcript on November 1st, and counsel said the following at page. Page 39, starting with line 15. This is Indian Hills Counsel arguing below, before the magistrate. The village heard, this is starting with line 15, I'm going to read to page 40, line 9. The village heard, the village council and the planning commission heard evidence with respect to how Peterloon is operating, where the money is coming from and all that. And they made the determination, they made a factual determination after applying the law that this was a non-commercial type activity. That's line 22. So I mean, when everything is said and done, I mean, I understand wanting to kind of poke holes at it, but again, and I'll let Brian deal with this more since it's his client, but from the village's perspective, Green Acres and a very large organization that charges for all kinds of things, but it's a non-commercial activity from the village's perspective based on how we've done it, and it's been that way for 40 years. That's pages 39 of the magistrate transcript 15.
So who's making this statement? Because I heard at the end, we've been this way for 40 years. Who's
Counsel.
making that statement?
Mr. Phillips, who is counsel for Indian Hill in front of the magistrate.
So that's argument.
Well, Your Honor, it also is set forth in the resolution 05-22 when they said there were no restrictions and they said we had the ability to
Okay.
do what we were doing. So
I
it's both.
appreciate, okay, I
Thank you,
appreciate
Your
your
Honor.
answer. Thank you.
Some of us are still old school people. Thank you, Your Honors.
Thank you.
Good morning, may it please the
Good
court.
morning.
If I may do the same with mine.
Yes. We can see that it has limited,
You start an argument with a complete idea of how it's
Of
going to go, and
course.
it never does. So, again, my name is Matthew Fellerhoff. I represent Jason and Joanna Paquin. Dr. Paquin is in the audience here. The Paquins are both doctors. They live in Indian Hill. They bought a piece of property, a residential piece of property, a residentially zoned piece of property, and a residential zone in Indian Hill, with the expectations that they would live in a residential zone in Indian Hill. Dr. Paquin is a cardiologist. Mrs. Dr. Paquin, this is the wrong way to say this, but works in Children's Hospital NIC unit. They have 2 small children. Beginning in 2021, when Peterloon hired an event planner and started planning, having all of these weddings, they suffered through nights of not being able to sleep. They had
and I appreciate that.
Okay.
And because you have 15 minutes,
Okay.
I would recommend maybe you get to your.
All right. Would you like me to jump into the?
Let's talk about the jurisdictional issue.
Certainly.
And like, I do appreciate your argument, as I indicated, Mr. Pacheco, that like, hey, I don't see an ordinance here. This doesn't look legislative to me. You heard his response to my query, like, what, persuade us that it's administrative.
This is fully administrative. It has every attribute of administrative. And I can go through the entire thing, but first of all, we had a conversation about continuing jurisdiction. This was an action under the Planning Commission's continuing jurisdiction. The Planning Commission gave an approval in 1980. I disagree with what the approval was, as typified by, as explained by Peter Loon, gave an approval. That was always subject to the continued jurisdiction of the Planning Commission to review compliance. And the reason I say this, there is section 101.481 that talks
So
about that.
in your view, that the continuing jurisdiction means it's, the Plan Commission 10 years later says, we don't like this anymore, or we're pulling the plug, no more weddings.
Absolutely, absolutely. Planning condition can do that, and for that reason, it's one reason why this is not a vested right, as has been argued, because it could be taken away. If you look at,
Counsel, doesn't that conflict with non-conforming use law?
this isn't a non-conforming use, this is a special exception. They didn't come in and operate it, and then the law was passed, which they were grandfathered. This is a situation where they asked for special permission to go around the requirements of the residential zoning. The residential zoning says you cannot do, there's no debate that under the current residential zoning, they cannot do that. What they asked for in 1980 was only the opportunity to have these meetings of groups like the Junior League, of a non-commercial basis. They didn't ask for anything more. The only thing that was
Was a
approved.
notice issued? Do we have a notice in the record that was sent from Indian Hill to Peter Loon explaining that the Planning Commission believed that they were in violation of the special exception conditions?
Well, and we cite the case law, there's no requirement. There are often opportunity, frankly, Indian Hill disagreed with our interpretation of Indian Hill's very clear language in their approval, because this is an interpretation of something that happened in 1980.
But isn't that a fundamental characteristic of an administrative proceeding, is that it begins with some kind of notice, either by the applicant saying, I'd like to receive a permit of this, that, or the other kind, or by the jurisdiction saying you're in violation of something?
That's why I was going into the administrative code, the zoning code, which talks about the continued jurisdiction. If you look at the title, and I know titles don't mean title, but it says 10.48, continuing jurisdiction of Planning Commission, reconsideration and revocation. That's what this title is about. There is always the opportunity to reconsider and revoke. And when my clients and the other neighbors petitioned the Planning Commission, started in the Planning Commission, they asked the Planning Commission to.
Well, but I think what's odd here is they did reconsider, but they didn't revoke. And you're sitting here telling us that they had no option other than revocation. Anything else would be illegal.
Well, I said they could reconsider.
They
could
did,
revoke,
and they
we
disagreed
asked-
with your client.
There's also language that they can put conditions on it also. So my client.
And they did, and they did.
Well,
They-
okay,
But, so that's
But
my
the
question,
the
is like,
conditions have to be consistent with the zoning code. There are specific criteria in the zoning code for the granting of a special exception permit. Okay, so this was part of the review. My clients and the other had standing to ask for that review. When they asked for it, there is a remedy in the zoning code. If the Planning Commission does not grant that review, that remedy is an appeal to City Council. If you review it, the Planning Commission didn't vote in favor of it, frankly, because they didn't have enough people show up to vote in favor of it. It was they needed 3 votes, and they only had 3 people showed up. It was 2-1, and there was somebody who wasn't even on the Planning Commission. They didn't have enough people there. That's why it was denied. Okay, these standards, as they were submitted by Peter.
Attorney Kellerhoff,
Okay.
I think I want to bring it back to why we're here.
Okay.
Because at the end of the day, we're here to review a decision that was made by the trial court.
That's correct.
And the trial court affirmed the magistrate's decision.
That's
And
correct.
we have a limited review,
Correct.
correct?
Yes.
So let's talk about that. The trial court said that the commission had misinterpreted the 1980 approval.
It did.
And that's what we have in front of us, is it not?
It's correct, except that this court asked to talk about
No,
jurisdiction.
I understand
So-
that. I understand that. So I want to bring it back to,
Okay,
like, this
certainly.
is what we have in front of us, right? And
Yes.
so, and at the end of the day, the magistrate and the trial court said that the 1980 approval was allowing for activities for groups and that they would be non-commercial. And
That is
because the
correct.
weddings were not an activity for a group, and because it wasn't non-commercial, then they did a remand, right?
Correct.
So can you address that?
Well, I can. First of all, the Peterloon only gets what it asked for in special exception. It didn't ask for, if it asked for permission to conduct weddings, we wouldn't have a complaint.
Right.
But what it did, if you look at the minutes, it says that it only had asked for the opportunity to have meetings for groups like, because it was asking in the context of a junior league meeting. And if you go on beyond that and you look further in 1990, if this was such a broad-based carte blanche that Peterloon could do anything it wanted based on that language, as Peterloon argues, why did Peterloon in 1990 have to go back and ask for permission to have a liquor license? And when it had the liquor license, it explained to the court, or I'm sorry, to the Planning Commission, that Peterloon wouldn't be in the business of being commercial, but it would have the sponsoring organizations, like the Junior League, to get the liquor license and do that. And why, if this was carte blanche and Peterloon could do whatever it wanted, why did in 1990 it have to go back to the Planning Commission and ask that Planning Commission for permission to have garden walks with its members?
But council,
It's-
it got that, right? And I mean, isn't a wedding included in the definition of a place of assembly? And why is it not an accessory use to a country club, a private golf club? I mean, I personally have attended many weddings at those kinds of venues.
Well, so there are two things. To talk about your first point is the fact that Peterloon had to go back to the Planning Commission to ask for every little thing means that the original approval did not include weddings. But to go to your questions about places of assembly, that, and I'm not sure which statutory provision you're talking about, because the magistrate indicated that Peterloon did not raise one of those arguments below. But getting to the question, those for places of assembly like country clubs and things like, those are for members. Those are for members. This is completely different than a commercial enterprise. This
How would
Peterloon is
we know that? Like, I understand the point you're raising that, I don't know, maybe pick one, Hyde Park Country Club or something, maybe you have to be a member to have your wedding there or something.
Mm-hmm.
But how would we know that on the record?
How would we know what? I'm sorry. you
How
said
would
that.
we know that baked into the 61.155 definition is a limitation on membership?
Because there is the other code section that Peterloon cited improperly talks about membership being required. That was, bear with me one second.
I
Okay.
understand what you're
Okay.
saying, that
Okay.
it's in this 1990 special exception for place of assembly that with the
Correct.
200 member limitation for the garden walks.
Correct.
And I-
But what we also know is that the residential zone does not allow that, but for the specific terms of the special exception. And the special exception did not talk about weddings. It only talked about groups such as the Junior League and of a non-commercial basis.
And could we go back? I don't feel that I got an answer to my question about the notice. So at the very beginning, when all of this started, was there a notice that was issued by Indian Hill to Peterloon explaining that there was some sort of violation or reinitiation of conditions or something that went out to them?
The notice was that the property owners had asked for this reconsideration jurisdiction. Peterloon got notice because it participated in, this was a year-long process where we had multiple hearings with all the
So it was
administrative.
a general public notice?
No, Peterloon got a specific because it was Peterloon's.
Well, but
specific.
then, to make sure I understand, you're saying this was a request for reconsideration of the special exception that already existed?
It was under the administrative process that's set up in the zoning code.
So,
in-
so if it's a request for reconsideration,
It was a request for reconsideration. It was a request to put more restrictions on under the requirements for special
But that's
exceptions.
different than saying it's entirely illegal. Because you got
Because
the different restrictions. Like, you got that.
No. So those restrictions we argued. So we had two arguments all the way through.
All right, well, let's stay,
Okay,
okay, let's
okay.
stay with my question.
Okay.
Like,
I
but,
apologize.
but, like, ultimately, that's not saying all of this is ultra vires. This is, we want there to be restrictions on this. And as I take it, like, you weren't saying, your clients weren't saying, there shall be no weddings under any circumstance.
What my clients were saying was the 1980, Peterlin said because of 1980, it could do whatever it wanted and no restrictions could be put on. What we said is the 1980 approval didn't stand for what Peterlin said. It wasn't that broad. It wasn't that. But we also said, if you're going to allow this, have it, put restrictions on, real restrictions on it. The restrictions that were adopted were Peterlin's restrictions, which we don't
Sure,
like. 'cause
sure.
it didn't
I
work.
understand that.
But so what happened here is there's nothing to prevent, and this court remanded it back to the city council, which I presume will remand it back to planning. There's nothing to prevent Peterlin for actually asking for a special exception permit to conduct weddings. And when that happens, Peterlin, those
Let me ask you a
controls can be
question
put
based
on
on
it.
what
It
you
just
just
hasn't
said.
happened. Okay.
Based on what you just said, and you've said this a few times, is it that there's a restriction on weddings? Or is it that there's a restriction on weddings as they were being done in 2021, because there's a specific notation of 2021 by Peterlin, which is that it's not by a group and it's for commercial.
So.
Do you see the difference? Because I keep hearing an argument, and maybe I've misunderstood when I've read the record. So do you see that there's an overall restriction on weddings? Or weddings as they were being performed on Peterlin that were not by a group and they were commercial?
It's primarily they were, so this is a residential
Do you understand what I'm
district.
saying?
So the residential requirements don't prohibit weddings.
Let me ask it a little different.
You can have a wedding at your home.
Let me ask it a little
You can't
different.
have a commercial enterprise.
Let me ask it a little
Okay.
different. So because the 1980 approval, Junior League was about renting part of the house to Junior League, and then Junior League was going to do events, right? But it allowed the grounds to be used for meetings and other occasions sponsored by groups, okay? So if a group sponsored a wedding, was there any restriction for that wedding to take place on the property?
It was groups other than the junior league.
Yeah, correct.
Okay.
So if there was a group other than the Junior League that sponsors a wedding,
Presumably, if it was not on a commercial basis. What Peterlin was doing was running an event center.
so the answer to that is it would be allowed, right?
The requirement for it, it doesn't say weddings. Weddings are allowed, are not, weddings on their own, an individual wedding can happen at a home, but you can't rent it out to have weddings. The problem is.
that's not what I'm asking.
And obviously, the problem is.
I think
that-
we're saying the same
I
thing.
think we are. I guess.
Because I think the argument sounds as if weddings were not allowed on the property at all. And really, weddings, it seems to me that weddings would be allowed if it's sponsored by a group. The issue is that there aren't weddings taking place that are sponsored by a group.
Correct. And the notion that a group, just to be real clear, it's probably going to hear this, that mom and dad are a group, it belies I just want to make sure.
I read it, I didn't have to hear it, but I get that.
Okay.
Okay.
So, and I, again, just
Well,
getting back.
but I want to understand the remand, because I don't really understand the purpose of the remand here. And as I read this, it says that the case is remanded to city council to hear the matters applying the proper legal interpretation of 1980 authorization. So if city council heard that and said, okay, that's all well and good, we're still going to issue a special exception and it's going to look a lot like this 0522, is that permissible?
Well, so the argument, what's confusing here and why I think we're where we are is City Council, it was argued to City Council, and I think City Council listened to it, that it had very little leeway in putting any restrictions on Peterloo because it had this vested right to run weddings. What was clear, and this was an argument that went all the way through this. Now, Peterloo's vested rights argument has now changed, but Peterloo's vested rights argument then was, we get to do whatever we want. And City Council and the Planning Commission had to make that decision with the added layer of Peterloo saying it had a vested right in this. Now, this
Okay,
could
so
be back.
their arguments are totally different, but could City Council still issue a regulation that looks very similar to 0522?
It should go back to planning, I agree with that. But I mean, it was, just as this court would remand back to the trial court, just goes back. It would go to planning, and if Peterloo actually asked for permission to run commercial weddings, it would do it under the special exception, it would actually ask for it, because it hasn't done that yet. It would do it under the special exception requirements with all of the standards, which include provisions to make sure that the neighbors are protected. That's not happened, and that's why the neighbors asked for this.
And
They wanted to be protected.
I mean, they don't want to hear the noise,
They don't.
right? I mean, that's
They
the
don't.
issue. So
Yeah,
if
the
they,
issue-
if they put a noise restriction on there, that protects the
Which they can, which happened in the instance
Sure.
of Green Acres, which is in the record, and the Mashawa House, which is in the record. It didn't happen with Peterloo because frankly, the original approval didn't deal with weddings. It didn't anticipate weddings.
Thank you.
Thank you.
Thank you for your argument.
Thank you, Your Honors.
Thank you.
Clearly, the 19...
Counsel, can I ask you the question about what notice went out? Did your client receive any particularized notice that they were in violation of something?
No, Your Honor, and there was no violation adjudicated, and even if, so no, we did not get any notice that anything was being violated. That's correct.
So what notice was received by Peterloo?
There was a notice that was received that the Planning Commission was going to address, and actually I can answer that question specifically. I pulled it out, Your Honor. In the Planning Commission findings of fact, this is at the record 208. The commission coming now to consider the request from John Von Lehman on behalf of the Forest Creek homeowners to place controls and limitations on sound, music amplification, and the number of events. That was what the Planning Commission hearing was all about. So to your specific point, no, there was no notice of violation because Indian Hill didn't believe we violated anything. So that's what this was about.
All right, so in my review of the record, I did not find any particularized notice.
That's correct, Your Honor.
I wasn't sure if one existed outside the record.
Not specifically to your question, no.
So from your review of the record, the only place that any kind of notice might be mentioned is in the findings of fact.
I don't know if I can go that far, Your Honor.
All right.
What I can go as far as to say is that's what it was about, and that was the only thing that we could ever be notified about.
All right, and how does that play into the legislative versus administrative question?
Well, thank you, Your Honor. To place controls and limitations on sound, music application, and the number of events. They are enacting new law. They are not applying existing law. They are enacting new law. It goes back to what we said in our original argument. The next step after these regulations are imposed would be an administrative act because you have existing law.
So how do you survive the issue that it's only applying to your client in this dichotomy of legislative versus administrative?
Yeah, fair enough, Judge. Because this still enacted new law, even though it applied to us. If you cite the Osborne case that is cited in Englehart, which both parties cited in the jurisdictional briefs, the Osborne case specifically dealt with removing a tow operator because the tow operator in Akron had moved locations. And the court still found that was a legislative act, even though it dealt only with Osborne and identifying a new tow operator. So, Your Honor, I would say that Osborne says just because it only deals with one entity or one individual doesn't make it an administrative act. So that's how I would respond to that. Your Honor, I would also go.
Well, thank you. Thank you for your argument this morning.
Thank you, Your Honor.
Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. We wish everyone a wonderful afternoon. Thank you. Good morning. So this is Ohio versus Dodd. How are you doing this morning?
Good morning, Your Honor. I'm doing well, thank you. And just for the court's clarification, it is Aaron Potter. I think Todd was submitted on the brief.
Thank you so much.
You're welcome.
State versus Potter. Whenever
Angela
you're ready.
Glazer on behalf of Aaron Potter. I'd like to reserve, although I don't think I'll need it, 3 minutes of rebuttal time.
All right.
Thank you. Is the court ready for me to proceed?
Whenever you're ready.
All right, thank you. Over the weekend, as I was going back through the briefs, the procedural posture and reviewing case law, I found myself wondering, what am I asking the court to do here?
That was going to be my question
Yeah,
for
because
you.
it seems to me that it's moot since
Yeah.
it's been dismissed.
And unfortunately, I find myself in
So
a
my
unique-
question, that was my question, why is it not moot?
Yeah, and I am actually prepared to concede that issue this morning,
Okay.
after going back through all the briefs. I mean, in the very beginning, when Mr. Potter filed his original pro se motion for the delayed appeal, I think he did have an actual controversy because he was serving probation and he had been involuntarily committed for 38 days. But following all of that, the trial court actually discharged the criminal conviction. So that's what I would be prepared to ask the court to do.
Completely discharged it, so there's nothing, yeah. All
Correct.
right.
So I'm willing to concede that this morning, and unless the court has any other questions.
And you have nothing further, right?
No, Your Honor.
And so the state, I assume, has nothing further? Okay, so
I
then you're
just
going to
want to clarify that you agree that the appeal should then be dismissed
That's
as a
correct.
remedy.
That's correct, Your Honor.
Okay.
Thank you.
Thank you. Thank you both for coming in this morning. Okay, State v. Cook. Good morning.
Your Honor.
How are you doing?
Good, how are you?
Good, good. Did you have a good weekend?
I did, it was all right. How about
All
you?
right. Yeah, it was good. It was good.
I was hoping I might have a little more time to prepare. That's quicker than I was expecting. I would like to reserve, if I may, 4 minutes for rebuttal.
All righty.
And I would like to start with my first assignment of error, which addresses the sufficiency of the evidence. This case deals with, obviously, possession of drugs, and when the court reviews the transcripts, I think it's clear the only evidence that Mr. Cook ever possessed these drugs was the fact that he was in close proximity to them, that they were in his mere presence. And as the court knows, simply being in the presence of the drugs without more is insufficient evidence. And I cited 2, 3, 4 cases in my brief that kind of discuss similar types of issues. But in this case, that is literally the only evidence we have.
So, counsel, I suspect that your opponent is going to add some more to the calculus when it's his turn. Reading the briefs, I think the more that he's going to add is the fact that cell phones were found on the seat, that the drugs were in plain view in the car door, and that Mr. Cook had a significant amount of cash on his person. And additionally, that Mr. Walker, even though he said that everything in the car was his, he was unable to identify what that was. So can you address the entirety of those circumstances and whether that gives rise to constructive possession?
I can. First of all, I want to address the plain view that was referenced in the state's brief, and I kind of disagree with the fact that the drugs were found in plain view. I think when you read the transcript, what it says is when the officer opened the car door, he noticed the drugs in the passenger pocket when he opened the door. I don't think that necessarily means that they were in plain view inside the vehicle to Mr. Cook, because there is nothing in the transcripts to say how deep the drugs were in the pocket, would they have been visible from inside the vehicle. We just don't know that. All we know is that when the officer opened the car door, he saw the drugs in plain view. I think everybody can agree that in a passenger pocket, it's going to be much easier to see something if the car door is open and you're kind of looking down at it.
instead of just sitting there in the car next to them. There could be, I mean, there's probably things in my driver's side pocket that I don't know are there.
But aren't
right
all
now.
these considerations and the ones that Judge Kinsley mentioned too, like, aren't they ultimately questions of fact that the jury should determine?
I think they are questions of fact that the jury should determine, but I think the evidence in this case is clear that it's completely insufficient evidence to show that Mr. Cook constructively possessed these drugs. Judge Kinsley mentioned the 5 cell phones that were found in the vehicle. Once again, we don't know who these cell phones belong
It's
to.
like, but does your argument go to sufficiency or to manifest weight?
I argue both of them in my brief.
Okay. But it seems to me that this discussion about the drugs, that's what I'm asking, does that, about the visibility of the drugs, does that go to manifest weight, or does that go to?
I think it probably goes more to manifest weight. But going back to the cell phones, there's 5 cell phones in the car. I think 2 or 3 of them may have been closer to Mr. Cook in the car, but once again, we don't know who these cell phones belong to. It came up during trial, you know, did you run any sort of forensic testing on these phones to see who they belong to? Were there any text messages about drugs? And law enforcement did not do any of that. So we don't know who these cell phones belong to. We do know that the vehicle was not Mr. Cook's vehicle. I think it was, if I recall correctly, I think the vehicle was registered to the driver, Mr. Walker, who owned up to everything inside the car. I think the testimony also was that Mr. Walker had just recently picked up Mr. Cook prior to the vehicle being pulled over. There was no, the officer testified that he was completely cooperative. He did not make any suspicious or unusual movements. He did not try to dispose of the drugs or hide the drugs. He was completely cooperative. The only evidence the state could show is that he was near the drugs, and that is
Well,
just not enough.
counsel, and now some additional facts are coming back to my mind, I think, about this particular case. Like, wasn't there testimony from the officer that he had witnessed Cook engage in a prior drug transaction in a white car, and that he was able to identify him and make the connection between what had happened earlier that month, and then later he saw him in this red car, and there was an odor of marijuana coming out of the red car. So I think the state is going to argue that they can really pile on enough to build inferences that connect to your client.
So there was an odor of marijuana inside the vehicle. The drugs recovered were not marijuana. I believe it was fentanyl, if I recall correctly. So the officer testified, at least on the day in question, he did not observe Mr. Cook engaging in any sort of drug transactions. I know there was another case about a month prior where the officer believed that Mr. Cook had fled the scene. However, the trial court found Mr. Cook not guilty of that offense because I think the evidence was that the officer in that case said that he thought Mr. Cook had been driving the vehicle in the first case, but that was not proof beyond reasonable doubt, so he was found not guilty of that charge. But I don't believe there was any evidence that Mr. Cook on the day in question, or even close to the day in question, had engaged in any sort of drug trafficking or any sort of illegal activity. He was simply the passenger in a vehicle. And I do want to go back to the cash on his person. I think Mr. Cook had $511 on his person. The driver, who once again said everything was his, he had over $7,000 on him. So I think that's very important for this court to consider. I don't think that $500 is a large amount of cash. I think the testimony was that the street value of these drugs was about $1,000.
What does the record show as to who was charged with regard to those drugs? Was there more than one person charged?
Well, I cannot say for sure. I believe. And
So
I
the
don't wanna-
record doesn't show anything with regard to this?
As far as if the driver was charged or not, I can't remember off the top of my head. I believe the driver was charged. I just don't know what exactly, if he was charged with those drugs as well, or some other type of drugs that he had on him. I cannot say for sure.
Wasn't Mr. Cook the B charge?
He was to be charged, so. But that may have been from the, I can't remember if that was from the first case or the second case. So, I mean, I know there was Mr. Walker was charged with something. I don't know if he was charged with those drugs that were found inside the car, but, I don't think it's necessarily, as the state says in their brief or implies in their brief, a self-serving statement for Mr. Walker to say everything in the car was mine, because even if he wasn't charged with the drugs, he could be charged if he made a statement that everything inside the car was his. So it's not necessarily a self-serving where he's not at any risk for being charged just for making that statement. And I think the court has to also understand and acknowledge, just because, let's say that Mr. Cook did know the drugs were inside the car, even just knowing the drugs were inside the car, that is insufficient to sustain a conviction here. That is simply not enough evidence. There's case law that says knowledge alone does not equate to constructive possession. And at most, that's all the state can show here, is that he knew that the drugs were inside the car, and I would dispute that, because once again, the only evidence that Mr. Cook knew the drugs were in the car is the car door opened, and there they are. But we don't know if he saw the drugs inside the car. There's no DNA, no fingerprint, no forensic testing done on this. So it's making a lot of assumptions to get to the point that Mr. Cook constructively possessed these drugs. I do want to, unless the court has any other questions on the first assignment of error, I do want to just briefly touch on my second and third assignment of error, which address the voluntariness of the plea that Mr. Cook entered to some of the charges. As the state...
On that issue, counsel, what impact does it matter that the trial court did not actually impose the consecutive sentence and the driver's license suspension?
I don't think it matters, and I would concede that Mr. Cook was not prejudiced by the court not advising him of the mandatory license suspension or the mandatory consecutive nature of the sentences. I would concede that. However, and I cited this case in my brief, I believe it's out of the 9th District, TANCAC, T-A-N-C-A-K, when the court failed to advise the defendant during the plea hearing that failure to comply must run consecutive to any other charge, that it's a complete failure to comply with criminal Rule 11, and you do not have to show prejudice because it is a complete failure. So I would argue that whether Mr. Cook was prejudiced or not, it does not matter, because the trial court completely failed to comply with criminal Rule 11, which would then, because this was a quote-unquote plea agreement, because some charges were dismissed, then the entire plea should be vacated, and in that case should be remanded back to the trial court for a trial or a new plea agreement. But I would concede that there was no prejudice by the court not advising him, because he actually received the benefit of it by not getting consecutive time when he probably should have. Unless the court has any other questions, I would like I said, reserve 4 minutes for rebuttal. I don't have anything else, however, at this time.
All right, thank you.
Thank you.
Morning, Your Honors.
Good morning.
Good to see you. Do you want me to start with assignment of error 1 or with 2 and 3?
However
I don't
you
really have
prefer,
much
it's
in the way
fine.
of canned remarks this
Unless
morning.
anyone has any preference.
Okay, well, assignment of error 1, that's the weight and sufficiency argument. Ultimately, I believe it was maybe Judge Bergeron and perhaps you, Judge Zayas, had asked whether it was more of a question of fact or a question of law. We would submit it's clearly a question of fact, basically the weighing of all of these factors that I believe Judge Kinsley pointed out.
And there weren't any factual determinations that were made on the record here, right?
I mean, ultimately, whether there was constructive possession is a question of fact, right? Did he know the drugs were there? Did he constructively possess them? And I would say
Well, I'm
that-
talking more about the whole notion, the whole argument with regard to whether the drugs were actually open and obvious, or whether it became open and obvious upon the opening of the door.
Yeah, I believe Mr. Goldberg and I might have a bit of a disagreement relative to here.
But what I'm
Eric.
saying is there's no factual determination on that.
Well, I think you could infer that certainly from the fact that the court found constructive possession. It inferred
Well,
knowledge of
no
the drug.
articulated specific factual
Sure.
determination.
Sure. But, just Mr. Goldberg characterized it as a pocket. I would say it's more of a compartment. It's a plastic compartment in the side of the door. It's not like a compartment that closes up a pocket like was the case in Mitchell. This is not like Criswell, where you had the drugs that were in a trash bag within another bag. wedged between the seats, or Devon, where you had drugs in a car that the defendant was only leaning into. Here you had a defendant who is, first of all, in a car that has been subject to complaints of drug trafficking. There's drug activity going on in the car. They're smoking marijuana, apparently reeked of marijuana. You've got drugs that would, as we said, basically pretty open and obviously could be seen sitting in this compartment. You had cell phones all over the car, including, I believe, at least one that was in Mr. Cook's lap. You had Mr. Cook with a substantial amount of money, and then you had Mr. Walker, obviously, who was, to clarify the record, the A defendant in the indictment. Mr. Cook was the B defendant. He said, well, everything in the car is mine, but he's unable to articulate what exactly is in the car. Unless the court has any questions relative to that, I'll get to assignments of error 2 and 3, which have to do with the Crim Rule 11 colloquy on the other case.
So do you agree that this is a complete failure case?
I don't believe it was a complete failure. Mr. Walker was.
So where in the record was there some attempt by the trial court to provide notice?
Well, so Mr. Cook was certainly put on notice about the fact of the consecutive sentences. I mean, the court indicated that it could be a possibility, apparently unaware that it was mandatory under these cases.
Consecutive sentences generally or specifically to the failure to comply charge?
Well, they were talking about all of the offenses, with which we had, obviously, the drug offenses, which I believe all merged, and then you had the failure to comply, which he pled to.
So is your argument by referring to it as could be that that's substantial compliance to the mandatory nature of the consecutive
Certainly under
sentences?
circumstances such as these, or where really, looking at this again, I probably should have just said this was harmless error because Mr. Cook was not prejudiced by this at all. And under circumstances such as these where the court didn't impose it, I would say that at least the advisement that the license suspension was a possibility and the consecutive sentences were a possibility is good enough under these circumstances.
Does harmless error apply to Rule 11 violations?
I believe there are decisions out of the 4th and 5th District. I was asking myself the same question this morning, and I didn't cite them in my brief, obviously, because I apparently missed an opportunity here to raise the issue in my brief. But yes, there are cases out of the 4th and 5th District, at least, that say that Crim Rule 11 can be harmless error.
Even with, if we were to find that this was a complete failure, we could still say it was harmless because the trial court did not actually impose these
I
punishments?
believe you could, yes.
Okay.
Thank you.
Thank you.
Just briefly in response. First of all, we keep talking about a substantial amount of cash. I will once again reiterate, I would submit to the court that $500 is not a substantial amount of cash, especially when the other defendant has over $7,000 on his person. Yes, there may have been one cell phone on Mr. Cook's person or on his lap. Once again, we don't know anything about these other cell phones. We don't know who they belong to. So the state is asking the court to make some assumptions here about who these cell phones belong to, but there's simply no evidence in the record about who they belong to. And just to briefly reiterate other cases that have found constructive possession in similar types of cases, there's actually 2 different Williams cases, but in both of those cases, in one Williams case, there was evidence that the defendant was the registered owner of the vehicle, that twice before he had received some type of parking ticket or moving violation inside that vehicle. So there's been a connection established between the defendant and that vehicle. And then in the other Williams case out of this court, the testimony was it was a gun found inside the vehicle. Everybody else inside the vehicle denied ownership or possession of the gun. And there is testimony from other people in the car that nobody observed the gun until the defendant, Mr. Williams, had gotten into the car. And I think those cases are different because they do establish some connection between the defendant and the contraband.
Well, so there was the statement that he had been seen dealing drugs out of a different car previously. Is that probative to the overall analysis? In other words, like, this wasn't someone who's like, I've never touched drugs in my life. Like, I don't know what you're talking about, right? And is that fair game in this consideration?
I think it could be relevant, but I think the court has to take into consideration that even if that prior drug transaction did occur, we're talking about something that happened at least a month ago. And like I said, in that case, Mr. Cook was found not guilty of being the operator of the vehicle. So I would argue that the evidence did not even establish that he was the one that law enforcement observed trafficking drugs in that situation. It was pure speculation on the part of law enforcement. Just because somebody's a drug trafficker doesn't mean that anything found inside the car is going to belong to them. I would concede if there was evidence that Mr. Cook had been observed trafficking drugs shortly before these drugs were found inside the car, then that certainly could be some type of a connection to the drugs, but that's simply not what we have here. That's something that happened several weeks ago, and once again, it's not even definitive whether or not it was even him. He was found not guilty of most of the charges related to that vehicle in the first case. So, once again, it's mere presence. There's nothing more, no other evidence connecting Mr. Cook to these drugs. So respectfully, we are going to ask the court to vacate the conviction that's referenced in assignment of error 1, and then vacate the plea that's referenced in assignments of errors 2 and 3. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision. I hope you have a wonderful afternoon. It looks like the weather's going to cooperate. Just give me one little moment, Karen. Let me get all my stuff here, all my accoutrements here. All right, so that concludes the proceedings for today. Thank you so much. Thank you, Karen.